If I may be heard as to a part of that, we're going to split some of this argument up, if you don't mind. And I would like to address the piece of that that has to do with the LDVR footage, the LocoCam footage. First, I'd just like to make clear that CSX is not seeking to seal the record. This is not a motion to seal. We understand completely that there is public interest in what happened here, particularly as it pertains to safety filming, and we're not trying to quash the public's interest or the press's interest in finding out what's been filed in the case. We are looking only at some protection for the videos that are in the case and the photographs in the case. And if you would allow me to give a little background to the court about the mechanics of this. Most of the locomotives that CSX uses these days are made by General Electric. Most of those have a camera in their nose. It's called the LocoCam. And the purpose of that is to record everything that the engineer sees as he's going down the track. You can recover that footage if you do it in time. And I think you have about a 72-hour window in order to recover that, or it basically tapes over itself.
That system is
Hard drive?
Any idea what the capacity of the hard drive is? I mean, it seems like if it's a hard drive, it would have a fairly substantial storage capacity.
I think that's over our pay grade, Your Honor.
Well, mine too, that's what I was saying. All right, I'm with you.
So what is recorded comes out in kind of an odd format. It's called a VAM format, a VAM format. And if you were to take that out of the locomotive, you couldn't play it on your computer because it's an odd format. Instead of getting, let's say you have a 6-minute piece of footage that you're interested in. If you take that out, it's going to come in maybe 10, maybe 20 separate files. So if you try to look at it, it's not a continuous run for 6 minutes. In order to look at it as if the way the engineer saw it, you have to get some different software. And you have to get that from General Electric. And you have to buy a software package from them, and then they don't just give it to you. You have to agree to a license that you enter into. And once you give them the money, you get the software pursuant to this license, and you're able to play the video then and see it as in real time. So what happened here was that plaintiff's counsel knew that there was some VAM footage of the train involved in the accident, and also a couple of other trains that preceded the accident train, and they asked us to produce that. And we said, we'll be glad to produce that, but you have to get the software from GE in order for it to be useful. In the interim, while you're trying to get the software from GE, if you'd like to come to our office down on St. Simon's, we have it, and we'd be glad to show it to you. So they did. They came and we showed it to them, and in a few days they sent us proof that they had obtained the license. And I believe it was on October 22nd when we produced 3.
The extrajudicial statements that we're seeking to prevent, Your Honor, are the exact type of statements that by their very nature would have a substantial likelihood of materially prejudicing a trial. If you look at the content of some of the statements that have been made in the case that we have cited in our brief, I think you can understand the nature of these statements and why we're concerned about them. For example, Judge, in the Hollywood Reporter, they published an article with the title, "Midnight Rider, Sarah Jones Family Lawyer Blasts Train Track Owners." And the article then attributes a statement to plaintiff's counsel that CSX was blaming Ms. Jones for causing her own death, and that wasn't surprising given CSX's behavior to date. And although the statement was misleading, as we've pointed out in our papers, and we're not sure what behavior that they are referring to in the article, these are precisely the type of statements that are prohibited by Rule 3.6 of the Georgia Rules of Professional Conduct. The fact that this misleading statement was widely reported, that it was disseminated widely in the media, demonstrates the need for the relief that we are seeking now instead of as we get closer to the trial of the case. Regardless, Judge, of what plaintiff's counsel knew at the time that statement was made, those statements violated Rule 3.6 of the Georgia Rules of Professional Conduct. The trial publicity rule prohibits plaintiff's counsel or defense counsel from making extrajudicial statements if they reasonably should know they will have a substantial likelihood of materially prejudicing the case.
Do you guys saw Mark play?
No, Your Honor, we did not. We did not. Hopefully we can nip this in the bud now and avoid prejudicing a potential jury pool. But if you look at comment 5.A of Rule 3.6, it provides the textbook examples of the types of statements that should not be made. And these are statements regarding a party's character, regarding a party's credibility, regarding a party's reputation. And when you negatively attack CSX's character and reputation by editorializing about its allegedly poor behavior and the way that it's defending the case, you're not trying to advance public safety, you're not trying to advance the public interest, you're trying to prejudice public opinion against our client, CSX. We intend to try this case, Judge, in the courtroom. We're not going to try this case in the court of public opinion. We've been asked to comment on this case numerous occasions by the media and have scrupulously avoided giving any comments about it. If the plaintiffs are free to make disparaging extrajudicial statements regarding our defense of the case or providing their spin on the evidence of the case, there's a substantial likelihood that our right to a fair trial will be materially prejudiced. We don't want to lose potential jurors before we even start who have heard improper extrajudicial statements about the case. I do want to make it clear, as Jordan said, we're not seeking a gag order to prevent any comments about the case. Instead, Judge, and the First Amendment's not going to suffer if plaintiff's counsel's barred from further extrajudicial comment in the manner that we requested in this motion. To the contrary, we recognize the need to safeguard the public's right to information in a case like this, which is a lot of interest. But equally important is the need to protect the party's right to a trial by jury, so it's not unduly prejudiced before we select a jury in the case. We're also not attempting to restrict in any way public discussion about the safety issues of individuals, including film crews trespassing on railroad property or film crew safety in general. We strongly support those efforts. CSX is involved in those efforts through Operation Lifesaver, through its own safety department. And that's not a relief that we're asking for in the case. We're simply asking Your Honor at this point to enter an order prohibiting extrajudicial statements regarding, number one, the merits of CSX's defense of the case, and two, comments upon the evidence. Thank you, Your Honor.
All right, Mr. Chairman.
Thank you, Your Honor. I'll take it in reverse order. If you've been committing a crime by manipulating evidence and we've been accused of violating the ethical rules, I want to back up and just talk about this extrajudicial statement for a second. The night that this accident happened, CSX's police officers showed up at the scene, and they immediately began spinning CSX's version of events. And the very next day, CSX police officers were quoted in the paper as saying that CSX repeatedly, in writing, denied permission for the filming on their tracks. Well, that's not accurate. I mean, the story's a lot more complicated than that. So they have continuously tried to put their story out, and frankly, the media has reported it very much in their favor. I'm having a great deal of time, I'm having a hard time trying to figure out what they're complaining about, because the media stories have always been in CSX's favor. But with respect to this particular statement, what happened was there was an answer that was filed, and in the answer, CSX contended that Sarah Jones committed criminal trespass and that she negligently caused her own death. And that was their counter to our complaint. My clients, understandably, were very upset by that. And the problem with that argument is there's absolutely no factual support for the fact that Sarah knew that they weren't supposed to be out there. In fact, it's the opposite. The facts are going to show that the film crew was told that they had permission, and Sarah went out there and she was hit. So she did absolutely nothing wrong. And so when that was done, when CSX made that contention, the press reported on it. And there were a number of stories saying CSX accuses Sarah Jones of her own death, or causing her own death. And we responded to that. and we issued a press release in response to all of that press inquiry. And Bob put it up there. And I'll be candid with you, Your Honor, I've read it 100 times since they filed this brief, and I do not believe that this statement violates the ethical rules. But if the court thinks we went too far, then I'll apologize. I can tell you I had a very upset client, and we were trying to respond to what we thought was very serious allegations, namely that our client was a criminal and caused her own death. And so this response is directly responsive to that. But that's not really the issue that we're here today to talk about, because as you pointed out, if they really think that I violated the ethical rules, then they need to file a bar complaint. But they never said anything after this statement was made. There was no comment. They never called us up and said, we think you're violating the ethical rules. They waited until after we filed a motion to compel. And that's exactly what this is all about. It's the classic, when we file a motion to compel and we accuse them of something, they counter-accuse so that the court throws up its hands and says a pox on both your houses. And I think that's exactly what's driving this. But what the court has to decide is whether this statement necessitates a constitutional limitation on what we can say. That's the legal question that you have to grapple with. And so did this statement, in response to what happened, did it create a situation where the court has to make a specific finding that this statement was so bad that you're going to limit the speech of the lawyers, and you have to specifically find that there is a substantial likelihood of materially prejudicing a trial. The trial hasn't even been set yet, and yet what they're asking you to do, frankly in a very cavalier fashion in 2 pages of briefing, they're asking you to do something which is very, very rare. And I don't think the support is there for it, and I'm also somewhat frustrated by the fact that they would ask the court to do something that limits First Amendment rights of both me and my client without briefing it and without making sure that the court truly understands the ramifications of what you're asked to do and exactly what the test is that you have to meet. Now, I want to turn to this other issue, unless you have any questions of me on that statement, Your Honor. All right, this video issue. I agree. I'm having trouble understanding what they're complaining about with respect to the video. If you look at the 2 briefs they filed, they say 5 things if you kind of tease this out. First of all, the video that 2020 played was part of the public record. The showing of the video in no way harmed them. It says in their brief, we're not saying we were harmed in any way by the video being showed by 2020. They have no issue with the video once public record being accessed by the media, and they have no issue with us filing it in support of the motion to compel. And by the way, at no point did they ever ask for a protective order on this video. Now, I'll tell you how the media got it. We gave it to them, and here's how we do it. We have a policy in our office that we do not disclose anything that is produced in discovery unless it's part of the public record. And so we've been asked repeatedly by people in the media if we can provide them with videos, and I have responded every time, I'm not going to give you things that are part of the public, I'm not going to give you something unless it's part of the public record. But if it's part of the public record, then my view is if an attorney calls me up and wants it, I'll give it to him. If the media calls us up and wants it, we give it to them. And this happens a lot in our products cases where we have documents that consumer groups want. Now, there's a real easy way to deal with this that they just didn't do. If they really think that this is something that shouldn't be disclosed, ask for a protective order. So what the history here is, we asked for this video, and they said, well, you got to go purchase this software license. And we thought about fighting about that because there is some case law that says you can't go require a litigant to go buy software to look at something. But we just said, you know what, we want the video, and we're just going to purchase the software license. So we get the software, and Steve sends an email to him and says, look, you know, we want to copy this thing. And I don't know if you've seen the emails, but Steve specifically says, we're going to copy this thing. If you have any problem with us copying it, let us know so we can take it up with the court. And they said, well, we can't control what you do with it. You need to abide by the software license. So we get out the software license, which I'm going to talk about in just a second because we clearly haven't violated it. And it doesn't say anything about copying the video. It only talks about copying the software and the training materials. So then we send a follow-up email that says, just to be clear, you know, we're planning on copying this. No response. This thing that they filed a motion on and that they're now contending is a huge deal, no response. So they ignore us. We filed the video in support of the motion, and then they filed this particular brief, and they say, well, you've manipulated it. Now, one of the things I found very interesting is they've accused us of manipulating evidence in this case, and this is a big corporation. They could have brought in a tech guy like this guy right here, and they could have shown you the video that they're accusing us of manipulating, and they didn't do that. But let's do that. I want to put up the video that was filed into the court, and I want to run it side by side with the video that was shown on 2020.
Which is which, Mr. Cruz?
The one on the left is 2020, and this one is the one that was produced. As far as I could tell, the only thing that happened here was that they made it a little bit brighter and they slowed it down by 2 seconds. We figured that out. Now, that is what they have accused us of wholly manipulating evidence. That's what you just saw right there. I can't see how that is manipulating evidence, Your Honor, but the other issue is I guess they're contending that we copied. Well, first of all, I want to point out, in their brief, they say of violating this software license. Well, of course, the major problem with that is they're not a signatory to the software license. If GE thinks we violated the software license, they know where we live, there's an arbitration clause in the software license, and they need to come sue us, and we'll litigate this with General Electric if they really think we violated their software license. But the major problem with these briefs is they keep repeatedly saying they violated the software license, but I don't know if you noticed, they never cite to any specific provision that says we're not supposed to copy it. And the reason is because it doesn't say that. Bob, can you put that up?
What's
It's
up?
11.3, I believe. No, actually, I'm sorry. It's number 7. 7, the one you pre-highlighted.
Yes, sir.
All right, here's the software license. It says we have a license to use software and documentation, which is defined as training materials. And then it says, under no circumstances shall we modify, and all these other things, the software or documentation. What this says is we're not supposed to modify the software, and we're not supposed to do anything with the training materials. And then it goes on to say you're supposed to use the software and documentation and the video, that's the only reference to the video, solely in connection with the case, whatever that means. That's the language. Now, by the way, repeatedly they keep filing these affidavits where they don't put that language in there. They say it has to be used in connection with litigation. And you'll see they take the quotes out and then they put in litigation when it doesn't ever say that. And so repeatedly in this briefing they have misrepresented what this software agreement says, and maybe that's the reason why General Electric hasn't sued us about it. So we didn't modify it, you've seen that. We copied it after telling them repeatedly that we were going to do that with no response, and then the software agreement was not violated. So at that point, I really just don't understand what the complaint is, Your Honor. We filed something that they admit we had to file. The media ran it. They admit it didn't harm them. I think it's unquestionably clear that we didn't violate any software agreement. I don't understand why we're here. And that's the reason why we ask for attorney's fees and sanctions, because this entire argument, I believe, is completely frivolous and was done because we filed a motion to compel. And that's all I have on that, Your Honor. Thank you.